What has actually happened is that, I don't know if you all heard that saying, where I stand by my man. Some people have that belief, but I'm just using that as a phrase. But what has actually happened is those in public office or with it that's been involved in my case have committed some pretty serious laws. There are several co-offenders in my case historically. When I say several co-offenders or co-defendants, there are other organisations involved. In this case, and everything links to my personal profile that I've gone through personally. But what has actually happened is the public don't realise it, is that when people break the law, at the end of the day, they put themselves first. People would commit the crime and then they just ignore it, and then I've actually gone through, suffered the retaliation of my claims and my complaints. I went to the Supreme Court and I was served by 3 individuals. I was served by Peter and Sue, and one of them was a manager, apparently, and I had advised them at the counter that I had come all the way from another state to personally serve my appeal because my case has been sabotaged. The case is roughly, 2.5 years that it was going through the court process, and that the reason for the appeal, why it was dismissed, was based on the registrar's decision. And so I had to just give them a quick review of why I was late. I told them that I was appealing the judgment dated 20th of December 2018. There was a lot more involved in the whole case in general, and it was definitely an administration issue. But I also know that registrars aren't allowed to ask parties to amend something that has to be addressed in court. For that reason I said no, because it needed to be done properly in court. And yeah, there was just a lot of commercial issues surrounding that, the names of the party. Sue said no, you can't go any further. That was the end of my case. And I said no, that's not true. The law says that the case can go further. The case can go further according to the laws. So I said to her that the case is a high profile criminal case. My case is a historical case of cyberbullying and public scrutiny. I said to her that things are really bad for me because everybody's into everything. It's really dangerous and hostile, and that I couldn't even ringing the police. Nobody will help me when I do ring, but this has been going on for so long for me, for years. And even after telling her that, I said that the case is definitely 100% a criminal case. She was quite adamant that I couldn't take my case any further. It was quite obvious she didn't want to help me, or that nothing was going to happen. So I said, well, couldn't you, get a judge to review my appeal at least? I showed her the appeal. I even had the judgments there and the exhibits. And then she said she was going to take it and then get somebody, her manager, to look at it, who was actually apparently away and wouldn't be back until the next day. But I said to her, well, couldn't you just get someone higher to view, have a decision over my case? Because the law clearly says can be seen by somebody else. And so I actually showed her the law, and these laws are actually still active in the legislation. But my case was actually really dire straight. I was scared, and even though I didn't show it on the surface, I knew that I had to, have it in record in court that I had tried to reappeal this decision, because I can't go forward, and I felt like I was going down on a downhill spiral, which I have been historically for years. The other reason why the judge had supported the registrar's decision was he had put in there that the registrar actually gave me an opportunity to do what he had requested, for me to change the names of the party, and that I apparently didn't respond or meet the time frame that he had given me. However, that's not true, and I had actually submitted sufficient evidence to prove and back up that I did meet what the registrar had asked me to do. He actually rang me up and we spoke on the phone, and then he had given me till 4 p.m. on that particular day before he gave the whole appeal to the judge. So the judge is stating in the appeal that I didn't meet that request. Those are the two reasons why the actual appeal was dismissed, was because of those two issues. However, I was able to support and challenge those alleged allegations. Straight after the decision was finalised from the Supreme Court, I straight away rang the Supreme Court and asked them if I could appeal the decision. I was told over the phone, no, that was the final decision, and that was it for my case. It couldn't go any further. Of course, I wasn't going to take no for an answer because it wasn't true, and I knew I was within my right, to have all the issues addressed properly. However, in saying that, the judgments by the judges from the Court of Appeal and to the Supreme Court, there's no indication that the judges had actually cited any of the exhibits that I had submitted. He was quite adamant that they weren't going to consider, because I asked them if they could even get a judge to have a view for a judge's opinion, because I know that no competent judge would ever, overlook such a serious case, even though they were facts. But I also had exhibits. I brought everything, the judgments, the exhibit. He had actually basically made up his mind that he wasn't going to accept my appeal. He basically said, whatever the registrar decision, that is what we will stand by. Because I didn't want to leave my appeal, I said to her, the other reason why I had wanted to personally serve my appeal was because people were stealing my information, stealing my work. You see, the documents were missing from my appeal. When the court send it back to me, that I don't get everything back, or somebody has opened my mail. So that has been going on in regards to my personal anything, has been going on for years. So that's a reason why I took my appeal. Everything's done in advance. And I get so frustrated because I know that people are stealing my ideas and my hard work, or I'm lied to. And it is like a slave-like system, 100%. Emotionally, it's been really difficult, and I have suffered mental anguish, after the fact. When I realised after the fact, I went through quite a big process of grieving and trying to, keep my emotions on top, and the loss of my livelihood, and just mainly the reality of how serious what I have come out of, and just traumatized about the events of the times where I have felt I have begged for my life. And I'm talking about the time when I submitted, with the car accident and the protected disclosure, and then I was traumatized because I knew my situation was life and death. And I felt that kind of panicky at that time. I never told anybody, but I was scared as hell. I was absolutely petrified. I was also scared when they pushed me out of my job and then I lost my job. So I went through all that, and I was scared as hell because I was vulnerable. And I felt that same fear and feeling when I went to Supreme Court and I served my appeal, and I was rejected. I was prepared about the rejection. I did go there prepared that it could happen, and it did happen. And I was actually petrified. Like I was calm, I was collective. I told them that my situation was a matter of life and death, and that I was, going through public scrutiny. The police doesn't not working. Okay, so what you're actually viewing right now is the actual original judgment from the Supreme Court. So I'm just going to walk you through. I will be reading what's on the actual judgment, but as you can see, you're actually looking at it. I'm just scrolling it down as I read it. But this judgment is the actual original, and I thought I'll read it, and so you can see for yourself that this court case is a legit court case on my channel. So what you're actually citing now is on the right hand side is the court file number, and so that's it. That's what's in the court system. And so what you see now is the case is between Minna Kreishin, which is myself, I'm the applicant, and the first respondent is Carolyn Green, second respondent is Jane Reed Moss, and then we've got Steve Colpin, third respondent. So we've got court, the names of the judges is right there, with the names of the judges, who are William Young, Glaze Brooke, and O'Ryan JJ. We've got counsel applicant in person, which is myself, and we've got judgment and the date of the actual judgment that we've been talking about in the last few episodes, dated 20th of December 2018. So it's titled Judgment of the Court, and the application for leave to appeal is dismissed. There is no award of cost. Reasons, bracket 1, the applicant commenced proceedings in the district court against 6 defendants, including the 3 respondents named above, who claims in relation to the respondents related to mental health assessments of the applicant in which those respondents had been involved. Number 2, the defendants applied to strike out the claims. The claims against the present respondents were struck out. The claims against the other 3 defendants were not struck out. Number 3, the applicant appealed to the High Court against the decision striking out the claim against the present respondents. This was dismissed. She then applied to the High Court for leave to appeal to the Court of Appeal against the High Court Appeal decision. Leave was declined. Number 4, the applicant sought to commence an appeal against the High Court leave decision. The Registrar of the Court of Appeal declined to accept this appeal document on the basis that there was no right to appeal against a judgment declining leave to appeal. Rather, the appropriate procedural step was to apply to the Court of Appeal for leave to appeal against the High Court Appeal decision. The applicant applied for a review of the Registrar's decision. Clifford J. declined this application. Clifford J.'s reasoning differed slightly from that of the Registrar, but he confirmed that there was no provision for an appeal to the Court of Appeal against a decision of the High Court refusing leave to appeal. Number 5. The applicant then attempted to file an application for an extension of time under Rule 5(2) of the Court of Appeal Civil Rules 2005 to file an application for leave to appeal against the High Court Appeal decision. The Deputy Registrar of the Court of Appeal declined to accept the document for filing on the basis that it did not list the correct respondents. The named respondents in her application were City Med and Ministry of Health rather than the present respondents. The Deputy Registrar gave her the opportunity of changing the intitulating so that the present respondents were named as respondents, but the applicant declined. Number 6, the applicant then applied for a review of the Deputy Registrar's decision to refuse to accept the application for extension of time for filing. The application was dismissed by Brown J. He found that the Deputy Registrar of the Court of Appeal had been correct to advise the applicant that the respondents named in her application for an extension of time should be the 3 persons who were struck out as defendants in the District Court proceeding, and had also been correct to reject the application for filing when the applicant declined to do this. Number 7, the applicant then filed a notice of application for leave to bring a civil appeal to this court. Again, the Ministry of Health and City Med were named as respondents. The Registrar of this court accepted the notice of application for leave to appeal for filing, but changed the name of the respondents to those of the present respondents. Number 8, the material submitted by the applicant in support of her application for leave to appeal is wide-ranging in nature and raises a number of issues that are not within the scope of the application for leave. The only issue that this court could deal with if leave to appeal were to be granted would be whether Brown J was correct to dismiss the applicant's application for review of the decision of the Deputy Registrar referred to above. There is nothing in the decision of Brown J that raises an issue of public importance, and there is no appearance of a miscarriage of justice. That means there is no basis on which this court could properly grant leave to appeal, and the application for leave to appeal is therefore dismissed. Number 9, the court did not call upon the respondents named above to make submission, and in light of that fact, no award of cost is made against the applicant in relation to this application. Okay, so what I have just read out is the actual original judgment. So I just thought I would read out this judgment so you can see for yourself that this court case is on my channel, in this channel, Authentic Ingenuity Entrepreneur. Myself, Minna Crichton, who's actually narrating my channel. So what you are actually viewing in my whole channel as a whole is actually evidence to my court case. So This is the actual last judgment that was made in 2018, when the court case was actually proceeding in the courts. But in the last few episodes with the Supreme Court, where I actually personally served my appeal, I personally took a trip, overnight trip, to actually serve that appeal. And so this is will be the actual last clip involving that trip, and also the conversation that I had with the Supreme Court Registrar when I went to personally serve my appeal in regards to my court case. Don't forget to subscribe, press like, and I will see you in my next video.